Thanks, everyone, for coming today. Got a great turnout, certainly not surprised, given what we're here to see. My name's Dr. Craig Lundy, and I've been invited, given the pleasure to be your MC for tonight. And we are here to celebrate the launch of Over-Efficiency in the Lower Criminal Courts, a Key Problem and How to Fix It, written by Dr. Shaun S. Yates. Dr. Yates is an early career researcher who's quickly getting a distinguished academic profile in criminological and social legal circles. Shaun's worked in various criminal justice sectors, including the Magistrates Court and the National Probation Service. He's also contributed to research projects involving Manchester and Essex Police. And currently, Shaun serves as the university's Crime Challenge Champion Lead. In this recently published book, Shaun is offering readers a new perspective on what it means to deliver efficiency in the summary justice process. The book centers on the novel idea of over-efficiency, that you can have too much of a good thing or a necessary evil, depending on your perspective. This fresh perspective aims to influence policymakers and to be a key text on reading lists for students studying the summary justice process. So before I hand over to Shaun, I'd like to personally congratulate him on this achievement. And I'd also like to give a special thank you to the Center for Applied Research in Empowering Society for providing the wine and sandwiches and other funding that's helping us out at the moment. And I'd like to thank Nujejma Softik for her much appreciated efforts in making this event so smooth and fantastic. So, with no further ado, I give you Dr. Shaun S. Yates.
Yeah, I'm really glad to see so many faces in the room. This is the first time I've done a book launch or had an event like this, so it's fantastic to see so many people in so many seats for this event and this book launch. Okay, this is my book, Over-Efficiency in the Lower Criminal Courts. And I want to give a bit of context before we jump into it. So the lower criminal courts, that's your petty offenses, right? Like your less serious offenses. All the sort of sexy, dramatic stuff that happens in the Crown Court. All the sort of mundane, trivial things maybe happen in the lower criminal courts. Why should we care about these criminal courts? So my book says, listen, 95% of criminal justice begins and ends here. So this is criminal justice. Like it may seem for some people petty or small, but really this is the substance of criminal justice. All cases begin here. If you go to the Crown Court, so be it. But all criminal justice starts here. So if you want to change the criminal justice system to make it better, this is the place to do it. 95% of criminal cases begin and end here. So if you want to make the world a better place, this is the place to do it. Okay, so this lecture is going to be recorded. Just to let you know, so if you ask any questions, it will be recorded and be on the internet for all the time, so just be careful what you say. And the last thing I want to say is this talk, it's a lecture, it's a standard academic lecture, which is kind of weird for a book launch, because usually it's a panel of people that just discuss things, and yeah. With this, I want to do two things. So the first thing is I want to summarize the ideas in the book, which is hard, right? Trying to summarize all the ideas of a book into a 1-hour lecture, that's impossible. But I just want to get the key ideas across, because I think having it recorded is really accessible. So maybe PhD students look at this, maybe policymakers look at this, and having an online lecture, it's more accessible than the text. So that's the first mission. That's why I'm doing the talk. And the second mission of the talk is it's basically an advert. So trying to show you some of the things that we haven't talked about today, but are worth investigating. Okay, so this is the to-do list. Anyone who's had lectures with me, you know I'm quite a structured chap, and I've broken our lecture today down into 3 parts. So in part 1, I'm going to talk about what is this book about. In part 2, we're going to talk about observations of over-efficiency. So what did I actually see in the courtroom that made me emphasize this idea of over-efficiency? And then part 3, should we avoid efficiency reform in the future? And the spoiler is no, we should actually pursue more of it. Okay. So part 1, what is this book about? What is this book about? So the context of this book builds on the idea of neoliberalism. So Academics in the room definitely know who this guy is. It's David Harvey. He wrote this really influential book called Neoliberalism. And in this book, it talks about the idea of capitalism since around the 80s becoming more Puritan in its ideology. It's going to become more capitalistic. So moving away from the idea of the granny state, where the government has regulation over our services, we're now entering it into a new ideology in the West. It's more capitalistic. We want to use the free market to orient our society to have the greatest social good. So the idea is, if we have more businesses and less government, then the world will be a better place. That's what neoliberalism says, not what David Harvey advocates for. He's just describing the world, right? So within this idea of neoliberalism, where the world's becoming more capitalistic, there was a sub-idea called new public management, right? New public management. And here's what happened. The government said there are some sectors in our government, our services, that we just can't privatize. We just can't do it. So instead, we're going to do new public management. We're going to use capitalist ideology, profit margins, trying to be about efficiency and economy, and we're going to take those values and we're going to stuff them into our public services, try and run them as a business, right? And that's what happened in the 90s in the UK. So the criminal justice sector was starting to shift its values in the 90s. We've got a great quote here from Spiegelman, 2001. There he is, looking quite dapper. And he says this: perhaps the most definitive characteristic of the new public management is the greater salience that is given to what has been called the 3 Ps. Economy, efficiency, and effectiveness, in competition with other values of government activity such as accessibility, openness, fairness, impartiality, legitimacy, etc., etc. So what's happening here? The public services, including our criminal courts, are becoming more and more business-like. They're being ran as if they are a corporation rather than a public service. So what have we seen in the UK? England and Wales, that legal jurisdiction, what has actually changed in the last 30 years? So there's been a whole bunch of efficiency reforms. We've had reduced estates, we've shut down a whole bunch of our magistrates' courts, consolidated them, centralized them. You know, if we sell off these estates, we can get some cash for that sort of thing. Another reform we've had is push for greater cooperative case management. What's that mean? Our solicitors are typically adversarial, the defense and prosecution. They usually fight each other in the courtroom. But because it's becoming more about efficiency, we want them to work together so they can basically cut out all the fighting and get straight to the point, get to the end. The early guilty plea scheme, this says that if you plead guilty as soon as possible in the process, you can get 30% off your criminal sentence. Again, we're trying to get people to rush through the system. Live-link technology, that's just Skype for the courtroom, basically. Reduced legal aid provisions and the rise of DIY defense. There's a whole bunch of people that can't afford to represent themselves, and we used to give them legal aid, but nowadays we don't. We're trying to cut back on those provisions. The rise of amateurism, the decline of amateurism and the rise of semi-professional magistrates. So magistrates traditionally are meant to be people from the public. They come to the courtroom and they judge those criminals that come through the courtroom. They're amateurs. They could be anyone in this room. What's happened over the last 30 years is these amateurs, we've been trying to train them up more and more, so they're semi-professional, right? The courts are starting to use more specialized court processes, so now we have unique courtrooms that try and drive people through the system as fast as possible. We have guilty anticipated plea and not guilty anticipated plea. Again, it's all about getting people through the system as fast as possible. So I was like, okay, I've read all this stuff, but what to actually say? The first problem I found is that there's two camps in the literature, right? We have one camp that says the process isn't efficient enough. We need more and more efficiency. We've got these delays. We've got to get things done. It costs too much money. We've got another group of people that says that it's too efficient. We need to slow down, take stock, and really look at what's going on in the criminal courts. I was like, how does this paradox exist? So when I looked into it, we have basically a series of government-sponsored reports. This is old, 2001, LeVay, 1989, Leveson, 2015, and Ministry of Justice, 2012. And these guys say that we need to have more cost-effective justice. Basically, we need to save more money. Otherwise, our courts will collapse. And the second thing is justice delayed is justice denied. So the idea is that morally, if we slow down justice, we're failing victims. So yeah, that's why we need more efficiency. Then there's other guys, right? There's other guys. And these people say that all these reforms that we're having, like the live link stuff, like making the judges that are meant to be amateurs and professionalizing them, all this is, we're going too fast, too hard, and the process is turning into what's called mixed justice, right? Like McDonald's, it's fast and it's quick and it's cheap, but there's nothing substantiating beyond that. So they call it mixed justice. And they say that due process values like human rights, effective participation is being undermined, or at least we think it's being undermined, and we need to slow down and take stock. So what we have then, we've got this battle going on in the literature. I looked at this paradox, right? And I said, how can it be both? How can people be saying we need more efficiency? And how can we have people saying that we need to slow down the efficiency and go the opposite direction? How can this paradox exist? And that was one of the motivating factors for my research. I wanted to investigate this more. And the second research problem is that there's a lack of in-court observational research prior to 2014. This year, we've had something of a renaissance of court observation research. We've got wonderful people from Transform Justice here, and they've just recently, in the last 2 weeks, published 3 reports that have used court observation methodology, which is fantastic. But prior to 2014, this year, there was a sort of desert of court observational research. We had a lot of interview-based studies, but not so much court observational stuff. Last month as well, we had a great publication from Lucy Welsh and Judith Townend about open justice. That was a court observation study. So we're in a good place right now with court observational research. But when I was conducting this originally, we didn't have that data. So with all that in mind, those 2 research problems, I did this. I wanted to find out some truths about the world. I use a qualitative stenographic data collection method. Stenography is where you sit in the courtroom and you type super quick and you write down what people do in the courtroom, where they move, how they say things, all this sort of stuff. I did 6 months of data collection. It was technically 9 because 3 months of that was a pilot study where I was testing out my typing speed and that sort of stuff. It was a case study design, so I looked at 1 magistrate's courthouse and I looked at all the individual courtrooms within that courthouse. So just looked at one place. I analyzed the data thematically and I was good to go. However, I didn't have a robust conceptual framework, so let's dig into that. The academics in the room, the criminologists and socio-legal researchers, they all know this guy. His name is Herbert Packer, and he wrote this text called The Limits of the Criminal Sanction. And he says this. This is back in 1968, right? He says this. There are people who see the criminal process as essentially devoted to values of efficiency in the suppression of crime. There are others who see those values as subordinate to the protection of the individual in his confrontation with the state. A severe struggle over these conflicting values has been at the heart of our courts in this country for the last decade or more. Added a little bit of flair to that last sentence. But yeah, there it is. Okay. So what Packer's describing is what I saw in the literature, right? There's like a battle going on. We've got our efficiency advocates and our efficiency critics. And the way that Packer describes this, he calls it the crime control model and the due process model. These efficiency guys, Packer says, it's like a conveyor belt. Our justice system is like a factory. It's about speed and standardization. We've got to throw people through the system as fast as possible. It's like a conveyor belt. Meanwhile, the due process guys, it's the word he uses. I say efficiency critics. He says these guys imagine the justice system more as an obstacle course where only the guilty get through the obstacle course. This is the imagery that he uses. And I was like, great, I love this conceptual framework. The final piece, I needed to define some key terms. So what did I mean by quality justice? What does that abstraction mean? Efficiency and over-efficiency, how do we ground these concepts? So this wonderful lady here, that's Jenny Ward. She was my examiner for my PhD. And in her fantastic text, Transforming Summary Justice, she frames quality justice as a collection of values captured under procedural due process. It's like human rights, verdict accuracy, fairness, giving voice to defendants, this sort of thing, and social justice. Now, this social justice thing is really interesting. What she says here is that in order to know how to punish people, which is criminal justice, when we punish people, we need to appreciate social justice, which acknowledges people's varying privileges and disadvantages in society. So how can we punish someone without recognizing their varying levels of privilege, right? So these are the key ideas that Ward couples with the idea of quality justice. I was like, I got it. I accept that. So what about efficiency? Isn't efficiency for quality justice, the idea of efficiency? I say yes, it is. But we need to get our priorities right. So any given criminal justice practice, any given practice, so whether it's live-link, whether it's the cooperation between solicitors, whether it's selling off estates, any sort of reform that we do, it's got to have these values in mind in this order. We've got to have values that relate to the philosophies of social justice and due process first. So that's your verdict accuracy, your fair trial, you're addressing social disadvantage. All these values have to be front and center, no compromise. And then once those are fully established, we then do all these things with efficiency, like speediness and cost savings and waste mitigation. That's how we have efficiency in a quality justice sense. It is always secondary to these values. Over-efficiency, on the other hand, is where we put the cart before the horse, where we make the system fast or cost-saving or about volume output first. And as a secondary thought, we put these values behind it. It's really simple stuff, right? But like this is the key grounding for the research. This gives the research some evaluative teeth. Yeah. Okay, let's get to the juicy bit. Part 2, observations of over-efficiency. Let's see what was actually happening in the courtroom. Okay, so academics who've done social science research, this will look very familiar. Here we have raw data, stenographic data. Legal advisor, please stand, stands. Solicitor 1 stands. Crown prosecution stands. Then the magistrates, M1, 2, and 3, enter the courtroom from the back. Legal advisor, good morning, your worships. Looks at papers, reads documents, scrolls through laptop. We have 10 matters this morning, etc., and we go through the court process like this. I'm typing away really quickly what's happening in the courtroom. That's the raw data. How do we analyze it? I applied codes to each line of this data, right? And this is called first pass coding. So, for example, managerial leadership, I highlighted the text here where the legal advisor is organizing the day, getting things ready. I was like, that is an initial code. It's a first pass code. That's managerial leadership. Another one's politeness. So when the legal advisor says, please stand, everyone stands for the magistrate to come in. That's a politeness thing. It's about etiquette. And then from coding the data like this, we then create second pass coding where we merge them all together, right? And then we do that one more time. We do one more merging. And we end up with overarching themes, right? This is classic thematic analysis. So the 3 themes from my data, from those 6 months, 9 months if you include the pilot study, of data collection, of being in the courtroom, seeing what was happening, was this. Key theme 1, speed-focused managerialism. This is what characterized the courtroom. Theme 2, standardized defendant processes. So trying to treat everyone the same, no matter their background, no matter what's going on. And the final one is court users procedural adversity. So no matter who you were, this process was like, we're going to make this a rough time for you, right? These are the characterizing themes. Okay, I'm not going to go through all of these, but I want to demonstrate what over-efficiency looks like, right? Like, what's it look like? So we're going to go through 3. We'll now discuss some speed and standardization-focused practices. The first one is a lack of defendant comprehension. So we put in speed before comprehension. Plea bargaining mid-hearing. So judges engaging in plea bargaining in the middle of a hearing. We'll explain more about that later on. And then finally, the non-public investigation and disbelief of defendants' mental health claims. Okay, so trying to treat people with mental health issues the same as people without. Okay, so. And I put here the factory symbol. It does look like a justice factory, like a conveyor belt. That's ultimately my sort of analysis. Okay. So I'm just going to go through 1 or 2 of these. But when we're describing the data here, I want you to think about how speediness is being prioritized over defendant comprehension. We're thinking about getting the job done rather than having the guy understand. Right? That's over-efficiency. That's over-efficiency. So case 1, legal advisor. Please stand, Mr. Defendant. Would you like your trial in this court or in the Crown Court? Defendant. Sorry, I never understood that. The legal advisor repeats the question again at pace. Defense solicitor, so the guy representing him, interrupts. He wishes it to be dealt with here. So even when a question is directed at the defendant, often the solicitors will just interrupt to put them down. Case 2, magistrate. Can we have an adjourning onto X date? Defendant. Can you put that in writing? I've got my address. Speech trails off. Legal advisor, no. we won't do that. You are here in court, so the onus is on you. Right? So here, the defendant's like, okay, so there's going to be a trial in the future. Please write this down. I was like, no, we've told you. You've now just got to get out of the room. We're going to bring on the next case. Over efficiency. Comprehension is getting grounded for the sake of speed. Okay, I'll leave this one up because I'm quite conscious of time. And you can always buy the book to see more examples. Okay, so now we get the idea. Let's go to a more complex case. Here we have a district judge emphasizing speed at the cost of verdict accuracy, making sure this guy's actually guilty, and impartiality, so the judge doesn't act impartially. So let's run through this case. District judge, yes, sit down, Mr. Defendant. I have read the report. I will say today that he is doing well on his supervision, and he is doing well. I have read the probation report. Defense has an advantage over me, sir. I still haven't seen it. District judge, I am saying here now that he, the defendant, is doing well, as he has got a job and he is working well. If he accepts his plea, then I will suspend the sentence. He is paying off his fines, and I don't intend to wish to waste the time of witnesses and victims. Would you like to have a word with him now? So this suspended sentence, this is a technical legal thing. And when a judge says, listen, you've got 3 months in prison, but I'm going to suspend it. So if you have good behavior now, you're actually not going to go to prison. This is your last chance. The sentence is suspended, but if you do one more thing, you're going straight to prison. That's a suspended sentence. So here, the judge is like, listen, if you say you're guilty, I'm not sending you to prison, but just say you're guilty. That's what's happened. Defense solicitor, yes, sir, leaves the court with his client. Some time elapses, the defense solicitor re-enters the room. District judge, are we going to trial or not, Mrs. Solicitor? Defense solicitor, no, sir. The defendant enters the docket. The legal advisor reads out the charges and requests the defendant's plea. Defendant, guilty. District judge, okay, good. Next case. So here we have, again, I'll say it again, we have speediness. The judge is like, get these things through. Like, we don't want to waste time at the expense of verdict accuracy. We don't know whether this guy is actually guilty. It could be the case that this guy is so scared of prison, that fear is so real for him, that he will plead guilty now just because he's confident that he won't go to prison. That could be happening. We could have just had the wrong verdict here. And impartiality, obviously the judge here thinks the guy's guilty before they've gone to trial. We're holding out the justice system. Okay, yeah, so what do we do about this? I've got two reforms, right? I've got two fixes. The first thing is the summary justice process should provide defendants with an immediate in-court receipt of proceedings. So at the end of each hearing, dead simple, it's not a major deal. We just write on a piece of paper, print it off. In the courtroom, it says, here's what happened today, and here's where you need to be next week, or next month, or at the next trial. In writing there, it's so simple. And I argue compliance, getting the guy into the next courtroom, is going to be higher. The next thing I argue is that the criminal procedure rules, which is like the statutory body that governs how solicitors act and judges act in the courtroom, these should be amended to make explicit that district judges don't engage in plea bargaining mid-hearing or mid-trial, because it undercuts the value of the justice system. Okay, so was the process overly efficient in other ways, other than too rushed, other than too speedy? Yes, it was too standardized. It was too standardized. Again, the idea is that the system is set up to get people through fast, and you do that by treating people the same, no matter the background. Right? So here, the cells officer was halfway through taking off the defendant's handcuffs, then puts them back on the defendant. The defendant is arguing with the cells officer in the docket, so it's like a glassed-off section of the courtroom. Details of this argument are inaudible. I can't hear what they're saying, but I know they're having a sort of spat. Legal advisor, Mr. Defendant, could you give the court your full name? Defendant, I don't feel very well. I need my medication. Let me out. I need my medication. District judge, that will happen as soon as possible. Defendant, let me get out. This is bullshit, yo. Let me tell you then. I'm on recall. This is stupid. I'm ill. District judge, please be quiet. So this drive to be like, we gotta get through this thing. Like there's a process we have to go through, rather than taking a step back and saying, can we take a moment to appreciate the welfare, the safeguarding of this individual, and ensure that this individual comprehends what's going on, okay? Because just because someone has a mental health issue doesn't mean that they don't have mental capacity. It can be both, right? So we need to take the time to appreciate that people with mental health issues fully comprehend the process. But in this example, standardization was prioritized, and these values, these quality justice values, were deprioritized over efficiency. Now, it wasn't just that sometimes defendants with mental health issues would be very loud. Sometimes it'd be the reverse. They'd be very quiet and childlike. Okay. So here the legal advisor says, do you have anything to add? Defendant, silent, no response. Defense solicitor, well, I think he knows, shouting at the client, the defendant, that you have been very fairly treated today. You are not going to do anything like that again, are you? Defendant shakes head. Magistrate, so do you have any help with at home? Defendant, no. Magistrate, do you live with anyone? Defendant shakes head. Magistrate, well, you need to appear X court at X date. Next case. So in this case, again, I interpreted the process, the defendant in this case, to be living with some sort of mental health issue, and I was questioning their capacity to fully understand what was going on. Same situation, standardization at the expense of defendant comprehension and safeguarding principles, right? Last one, disbelief regarding mental health claims. So as another sort of part of the general theme of standardization, district judges and magistrates often had this bias of not believing the claims of defendants when they said they were living with mental health problems. So here the district judge says, time and again I hear that he has mental health issues. He only has mental health issues unless he has been diagnosed. Defense solicitor, I have a letter here from his doctor here saying that he has ongoing mental health struggles. District judge, what does that mean? Has he been to see a psychiatrist? Has he a condition? Defense solicitor, well, gestures to papers, shows documents. District judge, I'll read it, pass it here. The district judge almost shouting, and the usher passes the document to the judge. So in this case, again, there's that sort of bias where it's like, oh, everyone says they've got mental health problems. Like, you know, there's a presumption that the person's lying, right? We've got another one here with magistrates. So the defendant just leaves the courtroom, and the first magistrate says, well, he'll be going to jail. Magistrate 2, yeah. Mental health. So this sort of like casual attitude of just not believing people with mental health issues, not having an attitude of, hey, let's investigate this, and even just be open-minded, just being impartial, just find out what's going on. That wasn't demonstrated in the courtroom. So again, safeguarding deprioritized for the sake of getting people through the system like everyone else, right? Okay, so what do we do about this? Well, I give policy reform recommendations, areas for further research. And one of the things I argue is this: further investigate staff's familiarity with liaison and diversion services. So liaison and diversion is our medical NHS teams. These guys are meant to investigate mental health claims and divert people out of the process if they live with mental health problems and don't have mental capacity. So further investigate staff's familiarity with the service, with a view to potentially offering refresher training for court staff as to better safeguard court users. There we go, there's the fix. That's how we can get over this problem of over-efficiency. But we've just scratched the surface. So there are other things I'd love to talk to you about right now. We just don't have the time. So legal advisors muting defendants on live link. So when they're using Skype, basically, to get a guy coming in from the prison, you'll just mute him. That's a lot of control over someone. Solicitors' pseudo-adversarial practices. So oftentimes, solicitors would meet up before a hearing. They would be really pally. They would talk about how the case was going to go out in the courtroom, and then they would enter the courtroom and they would act as if they're fighting each other, the defense and prosecution. But moments earlier, they've actually planned out what they were going to say and do. So it's a pseudo-adversarial system. And the court work group, trusting defendants to be truthful about their means, ability to pay compensation. So in order to give someone a sentence to pay compensation or a fine, you have to fill in a means form to say how much money you get. But in the courtroom, you just want to get that thing done. So we say, listen, John, just tell us how much money you've got. There's no investigation because we need to go tell you how much money to pay as compensation. So the defendant knows at that point, if he says he's going to pay, he gets no money, he's on benefits, he's not going to have to pay anything to the victim. And the reason the court wants to do this is to just get the thing done, you know? DIY defense practices, it's not enough legal aid, we've got some guys representing themselves, clogging up the courts, and much, much more. Okay, nearly done. Part 3. Should we avoid efficiency reform in the future? Spoiler, no. We should, in fact, pursue it. So we need more efficiency in terms of an adversity-free process, making the process not the punishment, right? So when people go through the court system, it shouldn't be something that's so long and painful for them. All that stuff should be reserved for the criminal sentence. I've got a few examples of how that looks like in the book. Let's just jump to one. Okay. So here in case 11, I want to demonstrate how the process is the primary punishment. And this mirrors the findings of Feely, 1979, with this book, The Process is the Punishment. So case 11, defendant. What would happen to me if I pleaded now? Legal advisor, what? Sorry? Defendant, so if I pleaded guilty now, could I get tried here? Legal advisor, why would you want to plead guilty, Mr. Defendant? Defendant, well, it doesn't change anything, does it? If I just plead now, I can get it out the way. I'd rather just get it done now. Legal advisor, the allegation is intent to supply. Yes, and I never wanted to do that. Legal advisor, no, well, the magistrates wouldn't allow that, obviously. So we're in a system now where the process is so punishing, it's actually more punishing than the criminal sentence, right? So this guy wants to give a false guilty plea because the process is just that demanding, right? Here's another example. Magistrate, I hope you realize that this is a matter that is something you should deal with directly. Defendant, yes, I feel it. I lost work over £1,000 just to be here. Magistrate, very well, you may leave. So it gets in the way of people's lives, right? They're missing work opportunities and this sort of stuff. So the process is the primary punishment. So there's room for efficiency here, making it adversity-free. That's the framing of efficiency we should have. So what next? So in the book, I offer 6 policy reform recommendations to improve the quality of our courts, and there are 7 areas worthy of further research. Right? Thank you. Thank you all for listening. There it is.
Fantastic. Okay, we do have some time for questions, but if you allow me to use my chair's privilege for a moment. Thank you so much for that, Shaun. I certainly do need to look into it. I know we've worked on stuff before, but I still can't get enough. I think there's loads in this book. I want to ask you, you mentioned a few sort of suggestions or recommendations there, but if you had to choose one reform to better the justice system, which one would that be?
Yeah, so I don't think there's like a silver bullet to improve the courts, right? It's more like it's been the death of 1,000 cuts. So there needs to be like a real substantial investigation and then a ground up holistic approach to changing this stuff. With that said, if I had to focus on one area, it would be on how homelessness, mental health issues, and addiction intersect to create unique compounded forms of social disadvantage. And these guys are really suffering, and they need a specialist way to get out of the system. So we don't have a robust problem-solving court system in the UK, and our liaison and diversion system with the NHS is being underused. So if there were people that were worthy of our attention, it'd be that, I think. Yeah.
All right. Will.
Thank you, Shaun. That was, I'm kind of reliving my days as a court officer for the probation service back here, even though that was some time ago. These issues are still very, it's really kind of vividly brought to life, which shows it's a long-standing kind of issue. Really, because it's so interesting, I'm working hard not to talk for too long, but lots of intricate questions that I'd like to kind of discuss with you over a coffee or a beer or whatever at some point. But I guess I always remember as a trainee probation officer in court, there was this very charismatic judge. My friend Davina might even remember it with Hertfordshire, but a judge called Judge Finley Baker at St Albans Crown Court. But his key issue, he gave a speech to every new member of the justice community, as he called it, be it prosecutors or solicitors. And he said, my main interest is always the person at the back of the court getting justice. And he said, and delays in any shape or form are not in that person's interests. So he gave this very impassioned speech about sometimes taking too long. It was often still today, sometimes court cases drag on for months, even years. he said that is not in the interest of the person who's going to be sentenced. So it's a kind of efficiency issue. I think that what that highlights me, I just had a question running through, is that this idea of efficiency on the one hand, and I think you have already spoken to this a bit, and justice on the other, often doesn't quite work in practice. Often efficiency, and also you talked about due process as well, and treating everyone the same, they're kind of classical principles on which the British, and also many European court systems are based on, is this idea of treating everyone with the same fundamental rights. So you don't vary the sentence, you don't vary the process, irrespective of who's in front of you. And that, again, you talked really convincingly about the need to cater for individual needs, but that is a real tension, isn't it?
I hear you.
If I'm making sense about how you balance these things. Efficiency does actually mean justice in some cases. Treating people in the same standardised way also is about justice. So I wondered if you could speak, just respond to that a little bit. Perhaps
Go on, give me 2 questions. Yeah.
Also, one of the other issues is about cuts in legal aid, which means that some defendants don't actually have legal representation. And I also remember in my probation days that I've actually been in court where there's been defendants who can't speak English.
Yeah, I saw that.
No legal representation provided. And it's at the Crown Court. And so, is it over-efficient or is it discrimination?
Just to add right afterwards, I mean, you mentioned NHS referrals. My wife works at the NHS, and I see her coming home most days, in a confused bewildered. That's not just because she's coming home to me. It's also partly when she's, the NHS, like all public sectors, can be completely and utterly decimated.
100%, yeah.
So, I mean, again, it gets us separating efficiency
I hear you.
from actual decimation of public services, which makes referring to mental health interventions or versions or legal aid much more, or meeting people's needs, much more challenging, doesn't it?
I hear you. Yeah. That's a lot. It's a long question. Yeah. So my response to that is we just got to get it right the first time, right? So having substantial upfront investment in key services, like with the homelessness, addiction, and mental health issues, like that requires an intense approach, right? And if we just keep doing these really soft touches, like a 3-week sentence in prison, then we wait 6 months, so it's another 3 weeks, that's not helping anyone. We're wasting money in the long run. So if we just took all that cash and did something really effectively once, ideally, just a really intensive course, maybe over a year period, maybe longer. And we know as criminologists that these systems does work in this way. And we also know that a small percentage of the population commits a large portion of crime as well. There's like reoccurring criminality and that sort of thing. So having a targeted, intensive approach, that's how I think you'll save money in the long run. In terms of justice delayed is justice denied, which is the speediness thing that you were talking about, Devinder. It is real. So part of quality justice is being speedy. Like, I'm not denying that. But my argument is simple. We've got to prioritize values that relate to due process and social justice first. And then it'll take however long it takes afterwards. We'll try and make it as fast as possible. But if we get rid of those, we've hollowed out the system. Now we're just being fast for the sake of fast. And what's the point of the courts if we're just doing that? So that's my angle on it. Yeah, Denise.
For me, I'm listening to some of the cases that you've displayed, and I want to ask a question. For example, when one of the judge or whoever said about mental illness of that particular person, I want to ask a question because obviously it's you were there, yes,
Yeah.
and that's your report.
Yeah.
That's what you saw. My question is in regards to, and I hope you don't get it wrong, and I hope you don't interpret it wrong. What I'm trying to say is that when the judge said, doesn't believe the person who has that mental illness.
Yeah.
From your observation, is it predominantly the BAME community, or is it a general thing? So I need in my head, something is playing in my head because I need to understand what you're seeing through your report.
Yeah.
So if you can help me to
Connect those pieces. Yeah,
Yes.
that's what you're saying. I 100% see your angle on that, and it does relate to the social justice stuff before, right? So there's a reason to go down this angle. In the report, it doesn't talk about race. It doesn't, like, there's no connection between any particular race and criminality and mental health connections. However, I am working on a journal now, and it specifically talks about, and again, it's not on a particular race, but in terms of discrimination on a particular set of people, it's people who don't have English as a first language, as a mother tongue. So if you don't speak English first and you go to the courtroom, the court generally treats these people differently to everyone else. And it doesn't matter what color your skin is, basically. It's, if you just don't speak English natively, then you're going to get a second degree type of justice.
No, my second question is this. With regards to reforming the system itself, and I think maybe 50 or 100 years ago, there's some element of that system still being transferred into now.
Yeah.
And I think that is where the problem is, because there is, things has changed, the society has changed, the social element of people's lives has changed, but there's still elements of the past still governing that system, and that is why things are taking that slow transition.
100%.
You know?
Yeah.
However, if the work that you have done and other people are on the same bandwagon as you, trying to highlight that there is a problem and the system itself needs reform, that's where the change will come. Because because you're in the system and you're in the justice system, you're not understanding that nothing has changed over 100 years ago.
Yeah, I hear you.
And it needs to change.
I'm on board. Let's do it. Yeah, revolution. Let's go. Yeah, great.
I really enjoyed that, Shaun. However, there was a dog that didn't bark here. To go back to the old homes. And that is the victim.
Oh, yeah.
I was fascinated by your micro-analysis and observations. But one of the big problems of the court is that it is a way of signalling to the rest of society about the nature of justice, whether people should respect what's going on there. And I mean, since packaging the classic study on due process and efficiency, what we've seen is in America and here in many countries is the rise of the victim movements, and Paul Rock and others have written much about that. And obviously, one of the problems for the court, for everybody working in the court, and also the politicians who held to account, is what is the clear-up rate, right? Who is getting punished? What signals are we sending out to the offenders? And what's the justice for the victims? Because all the emphasis on, especially liberal criminology, is justice for offenders, but the problem for people in the system, and certainly for the politicians, is also to signal to the wider population who are very, very frightened about low clear-up rates. Police are not even investigating burglaries, not even bothering, just giving you a crime.
Yeah.
They want justice in the sense of people being
Punished.
caught and punished.
Yeah.
And that signal has become very, very blurred.
Yeah.
And not least because of what you've described, which is the decimation of the system, the underfunding and all the rest of it.
Yeah.
Makes it very, very difficult to achieve any kind of justice.
I hear you.
There is a danger, I think, in highlighting the concerns, the needs, as you put it, of the offender, defendant in court, at the expense of the
Victims. I hear you.
Often feel they're completely shut out.
Yeah.
Despite all the attempts to highlight concerns and needs, they very often don't. Nobody bothers to contact them and explain that, this is the sentence that's been passed. But also, of course, when people reach the end of, say, a prison sentence, how often are the victims actually informed that, well, Bloggs is going to get out next week, and he may be coming back to your area.
Yeah, I hear you. I totally hear you. there's a risk of being maybe some would say a bleeding heart liberal where we're too soft, this sort of thing. Some people might argue that, right? So my angle on this in the book, I say we need to punish people. Retributive justice is part of justice. It's traditional criminal justice theory. But it's not just we don't go too far in that angle either. We recognize we need some of it, but we're not like a Puritan in that sense either. So I want to punish people that deserve it, basically. That's the short answer. In terms of victim-focused justice, I do talk about victims in the book, right? So Carnal Knowledge, Rape on Trial by Lees, 1996. She talks about how rape victims are re-victimized in the cross-examination process. They have to narrate how they were violated and a victim of crime. And that is, we've been victimized again, once outside and again in the courtroom. So with my research, I say, that's the Crown Court. Yes, it's very serious and totally different to the magistrates, but there is essence of that in the magistrates. So there is re-victimizing through domestic violence cross-examinations. There is. And what's probably most novel about my research, it's also true of defendants, so not just victims. Defendants have the same sort of, well, not to the mirrored extent, but they have an element of that as well. Like they too are sort of victimized by the process. So I do address the things you've raised there, and I think they are valid. Yeah. Yeah.
Thank you, John. I want to ask you one question. I will read this book with a pleasure, but I have a question because I am a student, and I remember like a couple of years ago when I was first year, and I saw you in front of me in the class, and I had no idea. I just knew that I wanted criminology to study. Like this is what I do. And now when I'm almost graduating, I can understand like more things. My question is addressed by social justice and criminal justice. How exactly we can persuade someone in the court case, someone that actually can also have like mental disabilities, and without because they could have these kind of things. We don't check everyone in the court like who has them and who doesn't, but how we can persuade someone in with social justice, in criminal justice, how we can like persuade the social justice people. For example, I see and understand the things, but people in court, they just want to get like as you said,
push them through. Yeah. So my response to that is that we need to do more of two things. So, well, three things really. The first one is we should be screening more people. So we actually should be screening more people. We should make use of liaison and diversion staff more often in the courtroom, which might require more investment. It just will. And then we need more of two other things: more problem-solving courts or intensive supervision courts. They've been sort of rebranded. And actual diversion, so pushing people out of the criminal justice net. We need both. We just need both. And we need both to prevent something that Miller describes in Donahue 2014 as the courtification of welfare services. Like, we don't want people who have a severe mental health issue to have to go through the court system to get help. We don't want that courtification of the system. So we want to keep all branches open to take people out if we need to. But then if someone does have mental capacity and just so happens to live with a mental health issue, then they can go to the problem-solving court, which is a specialist type of court. But we talk about that more in the book. Yeah. Thanks. Okay.
This is more a comment than a question, but I think the tragedy is that they're trying to get efficiency, and in trying to get efficiency, they are sacrificing justice, but they actually aren't getting efficiency anyway.
Yeah, true.
So you talk about over-efficiency, but in fact, if you go and watch a court, it's fantastically
Slow.
inefficient.
Yeah,
So
it's strange.
Nothing is achieved.
Yeah, it's bizarre. Like, so every year there'll be a new push for speediness and cost savings, and it just takes away from the critical infrastructure of the court system where it can't do anything. So we've rotted the system out by being too efficient. That's basically, I hear we're on the same page. Yeah. Cool.
I had a question which maybe speaks to the efficiency and victims point, which is often the court process isn't useful for victims and it doesn't end up with something that provides them resolution to the harm.
Mm-hmm.
I wondered whether you saw much of courts trying to push crimes to be dealt with out of court, where actually there are some good options for providing more rehabilitative, fast solutions, and I just wondered whether that came much, because that would also be probably the most effective way to make it efficient, just deal with less cases there.
Yeah, I hear you. So I did see some problem-solving light courtrooms. So they went full-on problem-solving courtrooms like we had in Liverpool Community Justice Centre. It was a drug rehabilitation requirement court. And here, people have been told to comply with a probation order. They have to come into the courtroom like once a month, something like this, and they have to talk to a magistrate in a casual way, so they're not like on different levels, on the same level, over a table, like one of these tables, and it's quite direct. And here, they talk about the problems. And I was like, oh, that's a way to get people out the system, right? Like you just described. I'm in favour of more problem-solving courts overall, but I do identify a big problem with problem-solving courts like the one I saw. What was it? Magistrates had a tendency to act like pseudo-therapists. So they're not qualified therapists, but in the courtroom, they would sort of lean into this. So the defendants that are on these orders, they have really complex lives. Like, people have been murdered in their family, the dad was a horrible person, all these like complex things. And they enter into the courtroom. There's a magistrate there, which is a volunteer judge, like anyone in this room. And then the defendant's like, I've got these problems. And the magistrate, it was evident that they were ill-equipped to deal with these incredibly complex issues. So I was like, there is space for problem-solving justice. I want more of it, but it needs to be tweaked in these ways. We don't want pseudo-therapeutic judges, basically. Yeah. We good? Yeah. Thank you all for being here. Let's have some more wine. And do you want to say something else?
Just join me in thanking Shaun for that lecture.
Thank you. Thanks.
There's a flyer at the front for information on how to buy it. You got to do that as well, right? So, and plenty of wine.